The Supreme Court of Ohio recently ruled that a submetering company that arranged with landlords to sell electricity to apartment tenants is a public utility, subject to regulation by the Public Utilities Commission of Ohio, or PUCO. The Supreme Court decision reversed a PUCO order that concluded that Nationwide Energy Partners, a submetering company, was not a public utility. The court's opinion stated that while originally a way for landlords to divide utility charges amongst tenants, submetering today is big business, whereby third-party companies buy gas, electric, and other services from a public utility and then resell those services to the ultimate consumer. Under Ohio law, a provider of electricity is a public utility when engaged in the business of supplying electricity for light, heat, or power purposes to consumers within the state. Applying this definition, the PUCO rejected a request to regulate National Energy Partners as a public utility, finding that landlords, not tenants, are consumers of electricity, and that landlords supply electricity while NEP is simply the landlord's agent.
I understand how it's functionally set up to avoid that NEP being the having title to electricity, but for all intents and purposes, aren't the consumers really buying their electricity from NEP?
No, they are not, Your Honor. NEP is serving as a billing agent. It appears as a line.
I assume if you ask most people in these apartments who they get their electricity from, they say, "Well, I write a check out to NEP every."
It's a term of the lease, Your Honor. It should be recognized by the tenants that NEP is the reseller of the electric service.
Writing for the court majority, Justice R. Patrick DeWine explained that PUCO's conclusion that NEP is not supplying electricity to consumers conflicts with the plain language of state law. Tenants who purchase electricity are consumers of electricity, and NEP is in the business of supplying electricity. Therefore, NEP is a public utility.
Yes, Your Honor. They handle everything from A to Z, cradle to grave. They oversee the conversion. They install the equipment that's needed for this private network at their own cost. They maintain the equipment. They arrange for generation supply at their discretion without any input from the landlord. Here, NEP pays the entrance fee. They take over everything. They get all the revenue. They incur all the costs. They collect all the bills, and they profit share with the landlord. The landlord is not involved in the physical or any of the service that NEP provides, and those facts are not in dispute. The only thing the Commission's saying, well, it's the landlord, not NEP, because of this piece of paper says so.
Because NEP is a public utility, the PUCO has jurisdiction to regulate its activities, the court concluded. It remanded the case to the PUCO for further proceedings. You can follow other cases before the court by visiting our website at supremecourt.ohio.gov and signing up for case activity notifications.